Right, what are we doing? Oh, that's amazing. That's amazing. That clock is almost right. Right. Okay, everyone. Welcome back. I want to start with a couple of admin things first. The first of which you might have been aware of, that I have on the bottom of the modules page on Canvas, I've put some practice questions from previous year's exams. These exams were not available on the university exams database because for some reason the university has only got space to put up 6 Word documents rather than more than that, so they only have the last 6 years' exams. There are exam questions there from previous years for you. I've also put on the amount of time you should be spending on each question in an exam conditions, under exam conditions. So if you're going to answer this question, you're going to spend probably about 45 minutes, for example, on that one. So if you're using those questions in a way to answer like you would an exam, that's the timing to do there. So those questions are there for you to use as you wish. and obviously a reminder that the exam is coming close. So keep practicing your and getting up to date with the content. The other admin is a couple of surveys to be aware of. Obviously, you're very keen to do surveys, but there's a couple of surveys to make you aware of. Firstly, set surveys for this course, for the lecturers, and for your tutors and tutorials are now available on Canvas. Please do take the 3 or 4 minutes it takes to fill it out. To do so, we find it very, very useful when people do respond, okay? It's only been open a couple of days, and currently the 1% response rate is not great. We'd like to increase that a little bit. Apparently, statistically, you need about a 30% response rate to make it meaningful, but any comments or feedback you have is all read. So even if we don't get to 30%, it's still very, very useful. So please do take the time to do that. I might give you a bit of time next week in class if the response rates haven't gone up, but don't take that as an excuse not to do it. Do it now. Not now, after this class. One example of, and this is called a feedback loop, so this is all very important from pedagogical reasons apparently. One example of where I have taken on board feedback, it's been in previous years that people have really responded well to me doing little summaries of the previous class at the start of this class, and that's why I try and do it every class, because of that feedback. So I do listen and take on board your comments. The other survey is from the class reps. It's through that QR code and is available on these slides for implied terms. So if you have a moment to fill out the survey, please do so, or just email your class reps directly. Cool. Okay. Let us finish incorporation, which we almost did on Monday. Remember, we were looking at on Monday the incorporation of terms that are expressed. So oral or written terms that the parties have actually, or one party at least, has made. And we saw that there were a number of different ways in which clauses that were expressed could be incorporated into a contract. And the most obvious and hopefully not counterintuitive is that if you sign a contractual document, the terms contained within it are incorporated into your agreement, and you are bound to them whether or not you read the agreement or understood the terms. As long as you weren't misled in some way in signing the agreement, and as long as the document itself was a contractual one, i.e. a reasonable person wouldn't have thought it's merely a receipt. And then we said, okay, well, even if you haven't signed the written terms, there are other ways written terms can be incorporated into your agreement. So we saw the ticket cases, where if reasonable notice was given that there were terms such that a person giving those terms could reasonably expect you to have notice of them and complain if you don't like those terms, then those terms are part of the contract. And what reasonable notice is depends upon the circumstances, including the onerousness of the terms in question. Because the more onerous, the more outside the usual course of business you are, and therefore more is needed to bring it to the other party's attention. So it might not be enough to say, hey, before you walk away, have a read of our terms over there on the sign. you might need to do more than that and say, before you walk away, have a read of the terms on the sign, and also be aware of clause 4b Roman 1, which means that I take your firstborn or something like that. i.e., the more onerous, the more knowledge is, or more notice is needed. Also, we saw in those cases that the terms that you're seeking to rely on must be available to be read prior to the contract being finalised. Once the contract has been entered into, you cannot then unilaterally introduce terms and seek to impose them on the other party. So in Chapelton, for example, the terms were held to come too late on those particular facts because the contract was concluded, and indeed performance could partly or entirely be completed prior to a user of the deck chairs getting a ticket from the attendant. Okay, questions at all about any of that before we move on? Make sense? You're all happy with that so far? Good, okay. Because there is one exception to that last point. You may still be able to incorporate a term that comes too late in this particular instance if you can show that the party you're seeking to impose these terms on, or enforce these terms against, I should say, has reasonable notice of them from a prior course of dealing with you. That is essentially that there's a history of contracting between these two parties. And each time they've contracted, the terms have been reasonably available. These terms have always applied such that a reasonable person would expect that each time he or she enters into a contract with this other party, those terms will be part of the contract. If you can show that, then the terms will be incorporated into the agreement this time, even if they were not handed over or if they were handed over too late. Because you'd say, well, it doesn't matter because you're not relying on this document to know what the terms are. You're relying on your knowledge that you've gained from your previous course of dealing. And that's what this case of Hollier and Rambler stands for and gives us a good discussion of when a course of dealing can be said to exist, or at least examples, and what notice is required. So like all these terms cases that we've been looking at on Monday and today, the clause in question is an exclusion of liability clause. So here you had the plaintiff leaving his car at the defendant's garage to be repaired. Before it was repaired, there was a fire at the garage and the car was severely damaged. It was held at trial that the fire was due to the defendant's negligence and that the wiring was faulty, which caused the fire. That was negligent on the circumstances by the defendant. So the plaintiff would normally be able to sue the defendant for negligence or perhaps breach of a bailment contract. The defendant, however, sought to exclude liability for negligence by relying on a clause that was in their sales invoice, which said that the company is not responsible for damage caused by fire to customers' cars on the premises. Now, this term was on the bottom of a form that the defendant got its customers to sign when they handed in the car. And if that's the case, and if that had occurred in this case, then the clause clearly would be part of their agreement, assuming that the form was obviously contractual in nature. However, there was no signature here, so there was no ability to rely on Lestrange and Gracob. Because the plaintiff didn't drop the car off and sign the form, instead the plaintiff had rung up the garage, had said, "Can you please repair the car?" The defendant had said, "Yes, I can repair it, but not for a while. We'll come and get it, or you arrange to get it to us. We'll store it and then repair it sometime." But there was no form signed. So there was no Lestrange and Gracob application. But the defendant said, "Okay, there's no form signed on this occasion, but you have used us for 3 or 4 occasions in the last 5 years. And on each of those occasions, you had signed this form. And therefore, because of our prior dealing, you should have known that this express term was part of our agreement this time. We've always contracted on these grounds. You should have known that you were contracting on these grounds again, and therefore, when you said okay to our agreement without making any comment about this, it's reasonable for us to assume you are agreeing to exclude our liability for fire damage." So there were 2 issues for the court. Firstly, was that argument correct? Was the term part of the contract due to a prior consistent course of dealing? And if so, did it protect the defendant from liability for negligence? We're going to ignore the second point. That is a exclusion clause question. And so those cases you looked at in first semester about how wide exclusion clauses are to be drawn applies. But suffice it to say that the defendant lost on both counts. Firstly, this term was not part of the contract. And secondly, even if it was, it did not protect them or exclude liability, for their own negligence. It was read down. But that second point was obiter because they already lost that it was not part of this particular contract. Why? Because there was no prior consistent course of dealing on the facts. Now, the first point the plaintiff raised was, yes, I signed these forms in the past, but I never read them, so I didn't know what the actual clause was. And the court said, no, that is not relevant. You had every chance to read those clauses, and by signing the document, you made it clear to the other party you had read and understood them, or if you didn't, you were still prepared to be bound to those terms, whatever they were. So the fact that you hadn't read those terms previously was not relevant to this question. What is relevant, though, is that on the facts, you could not say that the party's history was so consistent and sustained that whenever the plaintiff entered into a repair arrangement with the defendant, he should have known that there was an exclusion of liability for damage caused by fire. And the Court of Appeal in the UK relied for this on 2 House of Lords authorities, one of which said on the facts there was a consistent course of dealing, one of which said there wasn't. The first is this case of Hardwick Game Farm from 1969, where for 3 years, every month, so that's 3 or 4 times a month for 3 years, so around 100 times, sold notes had been sent to the buyer, and the buyer had never raised any protest or said anything which would have led the sellers to assume that the buyers were doing anything other than accepting the terms of the contract which appeared on the sold notes. In those circumstances, the House of Lords held that the terms of the sold note applied in this instance, even though the sold note was not given in time this particular time. Why? Because there was over 100 occasions previously. What's also relevant is that the fact that the buyer had never read the sold notes, had never read the express conditions, was not relevant. It was argued that because he had not read the condition could not be implied into the contract in question, although it had been made in exactly the same way as all the other contracts, namely orally, with a sold note in the usual form sent on after the contract had been made. The House of Lords decided that the fact that the buyer had not read the condition on the sold notes, having had every opportunity of doing so, did not avail him, because any reasonable seller in circumstances such as those, having had no intimation from the buyer that he took any objection to the condition, would have had good cause to assume that the buyer was agreeing to the condition. So, Hardwick Game Farm stands for the proposition that 100 contracts over 3 years on the same terms is enough to establish a consistent course of dealing such that you're bound to those conditions this time. Secondly, that a consistent course of dealing can be shown even though the party whom you are seeking to enforce the term against has never, on those previous dealings, ever read the condition. As long as reasonable notice of the conditions were given, such that it was reasonable to assume that they had agreed to those conditions. Okay? So you don't need to show actual knowledge. Constructive knowledge is enough. They should have known about these terms. And the court said in that circumstance, when you got a sold note with terms on it, you've received it over 100 times, you're bound to those terms this time. But then we can compare the other case from the House of Lords slightly earlier, which is named McCutcheon and David McBrain Limited. Surprisingly, it's a Scottish case, where the appellant had entered into a contract 4 times beg your pardon, that's not part of the judgment. What's that part of? That's the counsel's arguments. Whoops. Not part of the judgment, therefore not legally binding on us. Don't have to read that. Okay. There had been 4 occasions on which he had sent goods on this ferry from Islay to the mainland. And the court said that 4 occasions, it's not clear how long those occasions were over, 4 occasions was not enough to establish a consistent course of dealing for this time. And the Court of Appeal here in Hollier and Rambler said, look, if 4 occasions is not enough for a consistent course of dealing, then 3 or 4 times over 5 years, which was seeking to be relied on in this case, is certainly not enough. If it failed in McCutcheon, it must fail here. Remember the other case, Hardwick Game Farm, we're talking about 100 times over 3 years. So a shorter time period and many, many more instances. So we're not nearly at that level. We're not even at the McCutcheon level. And so if there was no course of dealing in McCutcheon, then there's clearly no course of dealing here. Furthermore, McCutcheon, or at least one of the law lords, Lord Delvin, had said to show a course of dealing, you must show that actual knowledge of the terms was proven, that is, that the party you're seeking to enforce the terms on had actual knowledge of them. That is clearly wrong, because we've seen in the later case of Hardwick Game Farm, the House of Lords held that there was a consistent course of dealing, even though the party whom the terms were enforced against had never actually read them. There was no actual knowledge in Hardwick Game Farm, and there was a consistent course of dealing enforced. Now, the Court of Appeal hints that this is wrong. I would say it is clearly wrong. McCutcheon is an earlier case. It was only one of the law lords, and Hardwick Game Farm overturns it. So the question you're all asking is, okay, so how many do you need? 100 is clearly yes. 3 or 4 times over 5 years is clearly no. 4 times over not sure how long was clearly no. So how many times do you need? The answer is, if you're somewhere in between there, you're going to have to argue it. You're going to have to argue it that there were sufficient number of times such that the plaintiff or whoever is seeking to rely on the term can show that the other party should have known that each time you contract with us, you are subject to these terms. And of course the other party will say, no, of course not. There were only 12 times. Who could be possibly have known that each time we contract with you, they're on the same terms? Because you're going to have to show that in an instance where you have not provided the terms to the other side, or at least not provided them in time, that the other part, that doesn't matter, that they're still bound by their history of dealing with you. That the terms are consistent, such that it's reasonable to assume that every time you enter into a contract with this particular person, that that term is part of their arrangement. And if you can, then you can incorporate that term through this prior consistent course of dealing, even if, in this particular instance, the term came too late. Because then you're not seeking to enforce the term based on this contractual document, you're seeking to enforce the term based on the other party's knowledge, or actual or constructive knowledge from previous dealings. Questions at all? Make sense? Happy? Any questions at all? Any incorporation issues? No? Well, if you do, you know where to find me. By the way, while I'm on that, I have office hours every Friday, it's 12 till 2, where you can come and ask me questions. I've also put up the times during the exam study period in which I'll be available. Just be aware of that. That's on, I made an announcement to that effect, I think last week. So just be aware of that and factor that in for your studies. Okay, we're going to move on from express terms to implied terms. What is the difference between an express term and an implied term? What's an implied term? Yeah.
It's a term which isn't expressed, but which is implied, some might say.
Some might say that. Are you using the definitional skills of the drafters of the contractual mistakes legislation? A mistake is a mistake. So an express term is different from an implied term because it's expressed, not implied. Great. Okay, good. Do you want to expand on that? What does it mean to be implied? Yeah.
I feel like it's an intangible sort of criteria on the contract, which obviously isn't written and clear, but it's necessary for the contract to work.
Great, okay, so it's necessary for the contract to work. What I'm getting at is it's not written. Not written by whom? The parties. We've been talking about incorporation of express term where at least one of the parties has written the term or spoken the term when we're talking about Couchman and Hill and Holly and J. Evans. And then the other party, by his or her conduct, has accepted that term. Therefore, it fits within the normal contractual framework of parties expressly agreeing to something and being bound to that term because they have agreed to it. An implied term is different in that neither party has expressly written it or said it. And you're holding that the parties are bound to it even though it's never been spoken prior to the contract. So, in effect, it is the courts writing a term and implying it into the contract and then holding to the parties to that term. We've already got a reason why they might do that, because it's necessary. What did you say? Necessary for the courts to do so.
Yeah, so that it makes the contract function.
Fantastic. So it makes the contract function. So the two parties have entered into this contract, or they think they've entered into this contract, and maybe they've even started performing it, and then suddenly they realise, or facts change such that they realise that there is a gap in the contract. The contract is silent about what's to happen here, and the courts imply in a term to make it work. It's analogous in some ways to the certainty cases you looked at the start of the year when you're looking at formation. That is, the courts don't want to hold that a contract is invalid for want of certainty if they can help it, because the parties assumed that they had a contract, they want to make it work. Well, similarly for implied terms, the courts want to make it work. Having said that though, why are the courts reluctant to do so? Or why will the courts only do so slowly and sparingly? Why would they be hesitant to imply in a term? Yeah.
Because it takes away from the fundamental principle of the choice of each party.
Great. Why does it do so? It does take away the fundamental principle of choice of each party, but how does it do so? You're right.
Because they didn't choose to put it in the contract.
Fantastic. Who puts it in?
The courts.
Excellent. So if contract law is all about enforcing the intention of the parties, then that's why the courts enforce a contract. Well, here we're not quite doing that, or at least there's a danger that what we're doing is imposing a term on the parties that they never agreed to, and then enforcing that term against them. Well, that's an imposition by the courts akin to torts or akin to the criminal law or tax law, but it's not what contract law is about. And that's why the courts are slow to do so. Having said that, the law reports are full of cases where the courts have done so. So it's not impossible, but just keep in mind what you're actually doing when you're implying a term in, and keep in mind why the courts might be reluctant to do so. Okay. So we've been looking at express terms so far, which are the terms that the parties actually said or wrote, which then might need to be interpreted. But the courts also imply in terms into a contract. And when they do so, these are not terms that the parties actually expressed. I'm going to start with a piece of judgment from Lord Simon in a case called BP Refinery from 1977, a House of Lords case, which we don't have that case in our reading list, but you don't need it because the only part of the case that's relevant is this part, and it's cited by most subsequent cases. And the reason it is because it's quite a useful starting point. The following conditions, which may overlap, must be satisfied to imply in a term. It must be reasonable and equitable. It must be necessary to give business efficacy to the contract so that no term will be implied if the contract is effective without it. It must be so obvious that it goes without saying. It must be capable of clear expression, and it must not contradict any express term of the contract. Why should it not contradict any express term of the contract? Anyone? Yeah.
That's once again a physical, very real physical expression of what the parties chose.
Yeah. And that would be really the courts imposing on the parties a term that they didn't agree to. In fact, they agreed something contrary. Excellent. Okay. One of the reasons why this is always quoted is it's pithy, it's short, it seems clear and obvious. It's in a numbered list, which everyone loves, numbered lists. You can sort of feel like it's a test you can apply. It's not a test. It's clearly not a test. These are conditions that the court says must be satisfied, but they may overlap. It's not a statutory test or code. It's merely Lord Simon's attempt, which has been cited on a number of occasions, to reduce the law of interpretation, of implication of terms down. It is often cited, but then it is qualified. And the leading New Zealand case on implication, 2021 Supreme Court case Bathurst Resources, qualifies Lord Simon's dicta at paragraphs 116. Now, Bathurst Resources is also our leading case on interpretation. And that's not surprising because interpretation and implication are closely entwined. That is, when you interpret the contract, that is when you might find that there are holes or not that need to be filled by implication. And also you will determine what the party's intention was and whether or not an implied term would go against that intention or would instead be giving effect to their party's intention. But anyway, paragraph 116 is New Zealand Supreme Court gloss on implied terms, and it's useful to start here. The legal test for the implication of a term is a standard of strict necessity, a high hurdle to overcome. Only if it's strictly necessary will a term be implied. Not just, certainly not just because the courts think that the bargain would be better if we imply this term in. You need the term in for whatever reason. This means that the starting point is the words of the contract. This is true for implication, but it's also a really good thing to keep in mind for any contractual dispute. What are the words of the contract? Figure out what those are. That's a good starting point. Now, there is one prior starting point that might be relevant, which is there a contract at all? But assuming there is, what are the words of that contract? So figure out what the words of the contract are. Does the contract provide for this particular eventuality? If it doesn't, then the usual inference is that no contractual provision was made for it. That is, the parties agreed not to agree anything on this point. There are strong analogies here to the court's approach to frustration. Does the contract provide for the circumstance in question? If not, the strong implication is the parties intended for losses to lie where they fall, or not to do anything about it. The task of implication only begins when the courts find that the text of the contract does not provide for the eventuality. But the implication of a term is nevertheless part of the construction of the written contract as a whole. An unexpressed term can only be implied if the court finds that the term would spell out what the contract must be understood to mean. How do we determine what the contract was meant to mean? It's an objective test. What is the understanding of a reasonable person with all of the background knowledge reasonably available to the parties at the time of contract. It's not, under E, relevant or doesn't depend upon proof of the party's actual intentions. Finally, BP refinery, which we just looked at. Those conditions are a useful tool to test whether the implied term is strictly necessary. And he said, and the Supreme Court says, conditions 4 and 5 must always be met before a term will be implied. What were 4 and 5? Firstly, the term must be capable of clear expression. If you can't clearly express the term, then you can't imply it in. Furthermore, it must not contradict any express term of the agreement. Okay, you must always satisfy those. But conditions 1 to 3 are only analytical tools which overlap and are not cumulative, which means you do not need to satisfy each of them. They are or, not and. And really what they're getting at is whether or not the term is strictly necessary. So is it reasonable and equitable? Is it necessary to give business efficacy to the contract? Or is it so obvious that it goes without saying? So the Supreme Court here is saying this is helpful, but it's not the test that you just apply and be done with. Okay? But it's a good starting point. And helps us focus on the question, which is whether the implication of a term is strictly necessary to give effect to what the contract, objectively interpreted by the court, must be understood to mean. Okay, so that's the general approach to implication of terms. What we're going to look at now are examples of when the courts have or have declined to imply in a term in a number of different types of cases. There are a number of ways in which these cases have been categorized. And unfortunately, like so many areas of the law, there is no one series of categorization or taxonomy which everyone has agreed to. So different lawyers, different judges, different academics divide up the implication cases differently. So do not be too caught up with whether or not this case falls within one category or the other. Just be aware that these are ways of trying to make sense of the cases and are good, useful ways for you to consider whether or not this is analogous to a case that we've looked at. But generally, and be aware that not everyone agrees with this taxonomy, there are a number of different ways you can imply in a term, or a number of different cases in which a term has been implied in. The first is when you can show that there is a well-known custom or trade practice which applies in all contracts within that trade. So whenever you get a plumber to do work on your house, is there a term of custom or trade usage which everyone in the industry knows, that it goes without saying that when you do the work, this happens? If so, the courts might imply in a term according to custom or trade usage. Secondly, as we've already heard, the courts might imply in a term because without it, the contract just does not work. It's necessary to actually make this contract a contract. Again, similar to the certainty cases you looked at in formation. Thirdly, the contract might actually work, but the express terms contained within the contract necessarily require another term implied in, or by implication they imply in a term. So it's not that the contracts need to make work, but that's just really what the express terms lead to the conclusion of. And overlapping, there are cases where terms need to be implied in to give business efficacy to this agreement. So practically or in the real world this agreement can work, but it doesn't make any commercial sense. There's no business efficacy unless we imply this term in. We have to be very careful here. This is in danger of the courts rewriting or trying to improve the bargain for the parties. That's not what implication is about. But it's saying this contract just doesn't work from a business or commercial sense. And finally, there are situations where the law, whether by statute, common law, or indeed equity, says for these sorts of contracts, we imply in this term. Again, that can only be the case if the parties have not expressly contradicted it. And we'll look at a couple of statutory examples of this. Okay, so don't be too concerned about the categorisation, but it is helpful to think about, I think, for trying to figure out if this particular circumstance a term should be implied in. Okay, going to very quickly start off with that custom or trade usage example. This was a drainage case, Woods and Ellingham, New Zealand. Bit of general legal knowledge. 1976 Supreme Court. What level are we at? What level of the court hierarchy is that? Is that the highest court in New Zealand?
It's like the High Court.
Fantastic. It's the High Court. Because confusingly, up until the late 70s, the High Court was known as the Supreme Court, which was not supreme in the hierarchy. It was the High Court. Only from 2002, 2003 is the Supreme Court what we know as the Supreme Court. Okay? So just be aware of that. Historically, the Supreme Court meant the High Court. So at the High Court level. Woods and Ellingham. So the first defendant contracted to build a water treatment plant with the second defendant, and the first defendant got the plaintiff in to do some drainage work as a subcontractor. There was no contract signed between the parties, but a price for the work, a fixed price for the work, was agreed to. Bless you. The plaintiff had difficulty with the water table and with flooding. In short, the work to lay these drains turned out to be far more difficult than they'd expected, which meant, of course, that the time taken to do the drainage work was increased, which meant, of course, that the costs on the plaintiff increased. And it meant that the contract price for doing the work was not sufficient to cover those costs. So what do? You try and get more money out of your contractor. The plaintiff sought more money for the job that they were doing based upon an implied term according to custom or trade usage. And that implied term was, whenever you do drainage work, you are to be given notice by the owner of the land whether there's any abnormal terrain which might affect the ability to do the work. And if you don't get knowledge or don't get given notice of that prior to the contract, then the owner of the land is taking on the responsibility for any extra costs incurred, due to that difficult terrain. So the question is, should that term be implied in by custom or trade usage? And Justice Henry adopts these principles straight from Halsbury's Laws of England textbook. And effectively what Justice Henry says is, yes, you can imply a term in by custom or trade usage. But in order to do so, you are going to have to lead evidence that this custom or usage exists. You must show that the usage is notorious, i.e. well known. Notorious doesn't necessarily have negative connotations, but it's well known, and that the usage was certain. That is, everyone is certain what that usage actually was. And you then have to get evidence from those engaged in that trade or custom to come in and say, I'm an expert in this area, I've got lots of experience, and yes, of course, whenever we're contracting, this custom or trade usage is always goes without saying. You don't need to write it into the contract because it's always what we contract on the basis of. You must show it's universal, so everyone accepts it, and it's ideal, and in fact you're going to be hard-pressed to prove it, ideal that your witnesses give concrete examples of when it's applied. Now, the usage does not need to be reasonable. Compare the BP refinery first condition. But the more unreasonable it is, the harder it will be to prove that that usage exists. Because why would a trade or an industry have an unreasonable custom? Maybe, but probably not. And you've got to show more than mere opinion. It's not just, I think that there's this usage, but there is definitely this usage. I've used it, this is applied to me in multiple occasions, blah, blah, blah. And unfortunately on the facts, the subcontractor failed to prove that. There were few evidence experts called. The evidence was contradictory. Even the witness called by the plaintiff was far from being decisive. And so therefore the custom was not proved. So Woods and Ellingham shows that a custom can be used to imply in a term, but the onus is on you to show that that custom exists, and you're going to have to lead strong evidence that it does exist, and the plaintiff in this case just failed on the facts to do that. Cool. Any questions at all about Woods and Ellingham? No, we've got some decisive closing of laptops, so that suggests that you're all ready to leave. Okay, thanks everyone. I will see you on Monday, where we will finish implication of terms and start on incorporation. It is our last week together next week, but all good things must come to an end. But I'll see you on Monday.